So
Yeah.
oh, what about your hair guy? Do you just book it online?
Kind of a walk in, kind of.
We like we have to get our hair cut more often though, as guys. Like a once a month thing instead of twice a year. Yeah. No, you have to. There's an app. The cut and dry. Yeah. 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 You do the 1.5 to the fade with the hard part here. And then they rub your shoulders with the massage gun thingy. Mm-hmm. It's fancy. All right.
That's still allowed us.
I haven't been there, I just drove by it, it's next to Cava, which is really good.
Yeah.
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 Yeah. Yeah. That's usually, well, it used to be because it was right next to GameStop. And Max would get a free $5 every month. So we'd go get a haircut and he'd get a pack of Pokemon cards. And so that was like because he hated getting his haircut. But then he's like, all right, we get our haircut, we get a Pokemon pack. But now they don't sell Pokemon packs anymore. They're all like hard to find. So Pokemon packs? Oh, cool. Yeah. Are they cards or packs? Oh, cool.
I haven't out when forgetting. I'm given one reason.
Oh, yeah. Yeah. Hi, Lisa. I did not have anything planned, so I was going to ask questions and see what people wanted to.
Yeah.
All right, and you know what? I am,
You need me to make copies of anything or
I
anything?
think I might. I am kind of running by the seat of my pants here today.
Everybody.
Like everybody. Hi, Miss Laura, hi.
Help set you up on any of that.
Okay, give me just one second, Jake, just kind of get my,
Yeah, no worries.
you know what, together. And
While she's doing that, did you guys have anything specific, questions, title work? Anything come up that we want to address at some point after Lisa's done all the stuff she has planned? Anything specifically?
Is wire fraud real?
No, it's been like a month since we had that team meeting, so we're good. They went away.
on defensive, so. Okay, if you would make, yes, if you would make copies of that for me. And guys, I am so sorry, but I want to get you the stuff for, it was just sitting there.
I printed it last night.
For Palm Agent, so I will be right back. I'm so sorry. Like I said, I'm literally running. No worries. Hey, Laura. Thank you. Thank you. Yes. Have you took that already for the event?
No, I'm not sure that I do.
Well, there's some confusion about that.
I think that I paid for it.
You may have to reach out to Haley because we sold tickets without names. So they have tickets.
It said that it was gonna send a thing to my email, you know, when you order the tickets, it was like processing it. And then,
All of us made the same thing. I got an email from Haley at the region said, hey, we have you down for 2 tickets. What names do you want to sign to them? I'm like, well, me and Caesar. And then Lonnie from the OP call, they put up the screen that we sold 180. And like 6 offices have 0 tickets. And all these OPs are like, no, let people go and get people. So they're trying to I don't know.
yeah, I don't have an email. Actually, I wonder if it even came out of my account. But
I can send you Haley's contact information.
Oh, yeah. Okay.
phone number and she goes, "Lizzie ran a little longer than anticipated."
Yeah, 'cause I was
So here
gonna,
we
I was
are.
gonna book. Oh.
Thank you. Cause I do. I don't like running late. Ever. Ever.
Is anybody online? Maybe your microphone?
You guys got
I don't like, I didn't know what it looked like, it just said they were,
Somebody must be here,
right? Usually, like, 2 minutes later.
Okay. All right. First of all, again, I apologize for kind of running a little by the seat of my pants here. But first of all, I want to start out with Palm Agent. Palm Agent is a great tool for you guys. It's a downloadable app. There is a very small fee for it, but when you're with a client, seller or buyer, you can run a cost sheet and have all of that information just pull through. So it looks very professional. You can get the information instantly. You're not referring back and forth from a card or notes or that type of thing. So that is a very useful tool, and I highly suggest working with that. Well worth it. How much do you know?
I think it's $19.99 a year.
Yeah, it's not much in comparison to what your, sometimes your business expenses are. Because it's right there. Yeah.
Determine like hazard insurance, that homeowner's insurance,
Yes, it is.
and so it says like it auto populated 0.68%. You just put a number.
Taxes.
Insurance, this is what
Oh,
comes
for
up
sure.
when I opened it. So like the.
That must be just kind of what it determines. If you put your sales price in there, it must just that must be kind of either the national average or the average in our area. I will be quite honest with you, I'm not sure, but I would have to think it would be in our area because you put in who your closer person is. And so it would know that you're kind of in the Cass County, Jackson,
Gotcha.
the Kansas City metro area, let's put it that way. So it must calculate that out based on that information. Oh yeah, Kansas City region, yeah.
In Johnson County, it's different than.
Hmm.
I just wonder how to, I guess I could just
How to
change
adjust
to
that.
dollars
Uh-huh.
and put in,
Whatever your estimate is.
yeah,
Did,
I
it,
just need to
did the
know what
dollars thing change?
it will.
Oh, there it is. Okay,
Yeah.
good.
I just need to get, I don't know what the average home insurance is, I guess.
There is none.
Yeah,
So if you're in the moment, I'm just curious how you guys figure that, like if you're in the moment with someone, they're like, I don't know, I don't remember what mine is, or I haven't checked on your insurance.
mhm.
I
You
would
just,
maybe just take the percentage and say this is just estimated. I would do
Yeah.
that.
Yeah, I'm sorry, I don't know how the other agents do that. Jake might be able to tell you because he's an insurance person too. Or Jakey, didn't you say Jakey? She did say Jakey.
I asked, yeah, like told me that one time at softball, home softball, like honest to goodness, it really.
Came out.
I don't think that team didn't. He was like 25 years old.
That's
something.
All right.
It would.
But now,
That's funny.
Okay, so get on to the topic at hand, and that is title commitment. The sample title commitment that we have here is a very old commitment, but it has a lot of mess to it, so it's kind of a good one to use. We created it, so let's hope that this is not any person that actually is out there and their mess. But Schedule A, oh, yes. No,
so this, what we're looking at is that thing that you send me before we close, right? That I'm supposed to make
exactly.
over?
Yes.
Okay.
Yeah,
Make sure I-
the title commitment, thank you. That's a good point. A title commitment is done saying, here's the information on this property. Here's who owns it. Here's the liens out on it. Here's easements that have been filed. Here's mortgages that have been filed, judgments, anything that is attached to the property that needs to either A, just be aware of, or B, actually, oh, thank you. Or B, actually just clear title. So it's a transfer of title. So that comes out so that all parties are aware, both seller and buyer. But also, we need to know what items do we need to clear to transfer clear title to the buyer, from the seller to the buyer. So ultimately, that's what a title commitment is. It's saying, here's everything out there. Here's what you have to deal with. A lot of the stuff, not a big deal. Standard exceptions, easements that are on the property that could be a driveway easement, could be oil and gas, it could be anything. But a lot of those things you don't have to worry about. The big things that you worry about are going to be on Schedule B1. So we'll get to that here in just 1 minute. Schedule A, though, which is the first part that you guys run into, is, oh, I'm so sorry. Yeah,
That's okay, I just heard from.
there we go. Is the one that's saying, this one states, okay, here's who's currently in title. Here's who wants to be in title. Here is how much you're selling the property for. So therefore, how much we are going to insure upon for an owner's policy. And then also, if you have a buyer on this one that's getting a loan, it'll show the loan policy. So how we're going to insure the lender. So this is also something that the lender is making sure that they have coverage. The owner's policy is the one that ensures the buyer that they have clear title. So once we've closed, recorded, funded, all of that is done, your buyer will receive an owner's policy. The owner's policy in our area is typically paid by the seller unless it's set out in the contract otherwise. I've never seen in a standard contract, a state board contract, that has changed. It could, but that's not normal. Sometimes in for sale by owners, we'll see that, though, where another party will pay the other party's fees. But we're unique in the, I'm so sorry. Sometimes. Yeah, I mean, sometimes you can always negotiate that. It's just not standard that we ever see it in state board contracts. So usually the only time we see it is unrepresented seller-buyer situations. So, the buyers are having to insure a loan policy for the lender. So the lender is saying, we want to make sure that we're insured also. So we're going to require our buyer to purchase a loan policy. So that's kind of the difference between the two. Owner's policy insures the buyer, and the loan policy insures the lender. Okay. In our area, it's unique in the Midwest that the seller pays for the owner's policy. And almost everywhere in the country, the owner's policy is paid for by the buyer. I just throw that out there because once in a while you'll get a buyer, especially if you get coastal buyers, they'll be like, this is really weird that, I'm not paying for this as a buyer. Are you sure I'm getting coverage? So the seller pays for that in our area, the owner's policy, to make sure that there's clear title so that somebody can't come back, an entity or another just owner, come back and say, hey, new buyer, you don't own this property, I do. Or, hey, new buyer, I have a lien against this property that you now need to pay because you own it.
It's just an insurance policy. Okay.
Right. Yes, title insurance is an actual insurance policy. We have to be insured just like, well, differently, but kind of just like any other insurance agent. We have different coverages that we have to insure under there. Correct. Now, going a step further, which you would not necessarily care about, but if they were to refi in the future, they would have to get another loan policy, but they get one owner's policy when they purchase. Okay. It also sets out legal description. So the legal description to the property is also listed here. So we've got owner's policy, we have loan policy, we have who the proposed insurer is going to be, so the buyer. And then we have who it's currently vested in, which is the seller. Okay. So when you look at your title commitments, as long as that information looks correct to you and you don't have a different seller than what's listed on here, then you're good on Schedule A. Okay. Schedule B1, which is the next page. Schedule B, Part 1. This is where the meats and potatoes come in as far as what has to be cleared. Once in a while on Schedule A, you'll see that it's mom and dad seller. And then when you get over to B2, then you see, okay, we've been informed that mom and dad seller are now deceased. So we're making a requirement of a death recital on the deed, a requirement of probate, or whatever the scenario is, if we even know, if we've even been informed that the seller is deceased. So sometimes you will see the seller's name on there on Schedule B or Schedule A, but then a requirement on B1, you got to deal with the fact that the seller is deceased. And here's what the steps that we're going to require for that. Sometimes we don't know that the seller is deceased, so you're not going to see that requirement. That's something that you guys then give to us, and then we can amend the title commitment or just tell you the steps on how to get that taken care of. So this particular seller was busy, very busy. So we have a seller who is David Jones and Leanna Brown. On Schedule B1, Item 9, there is a requirement of a release to, let's see, who's my lender? Community America. So Community America has a loan out on this transaction, and we need to get a payoff for that. Normal, nothing, no big deal about that. That's where your payoff authorizations come into play. When we send out those payoff authorizations, that's the information that we get from you. A lot of agents are having those payoff authorizations completed at the time they do their listings, because people typically have their information available. You're not having to deal with it after the fact, once a contract hits, oftentimes sellers will start getting their stuff packed. They don't have their information. With our online world that we have today, a lot of people don't get paper statements. So they have to look up their information. Online doesn't necessarily have a full account number. It's just, goes down a spiral there. So they have to call their lender, get that information, etc. So if you do that at listing, sometimes that's just helpful to speed things along when you guys get to contract wise. Next page, Item 10, it's showing that David is divorced from Carol Jones. So remember, David and Leanna are currently in title, but there is now a settlement out there for a divorce between David and Carol. So we have to pay out Carol whatever that settlement is stating. So when they divorce, the judge set out that Carol gets $50,000 or whatever it is. So we have to have a payoff, basically. So it'll show as a line item on your closing statement, $50,000. Carol is going to need to come in and sign a satisfaction to that. So in other words, we're not giving Carol $50,000 without her acknowledging the fact she's getting $50,000 and releasing that, because that allows us, with a satisfaction or a release, it allows us to be able to ensure the fact that Carol can't come back against our buyer saying, now you owe me the $50,000.
If she doesn't come in and sign today, close?
No. No.
Do we have any role in getting her in here, or is that all you guys?
The role will come in on an agent side if David doesn't want to provide us with the information. David doesn't, I can't tell you how many times that X will say, I have no clue how to get a hold of Carol. No clue whatsoever. And then when closing starts stalling out, then they can find, yeah, when they have the kids over the weekend, magically, then he can, but sometimes you do have situations though, where spouses have separated and they no longer have communication. We had one situation where through, in this case, I'm gonna use David. David's attorney had to contact Carol's attorney to be able to get in contact with Carol. So it ended up kind of weaving through that, but you get attorneys involved, and sometimes that's not their top priority because that is something that's already been paid for. They're done, they kind of
If an
going.
agent might Contact the ex and tell them to come in and sign with you, that comes. to Carol.
No, but you might have to help us encourage David to get us the phone number, or have David let Carol know we're going to be calling, because people don't, including myself, don't answer phone calls that they don't know. Just so sometimes in those capacities, but typically we wouldn't have you reach out to Carol
Okay.
in this case, in this scenario. Also, the item 11 is a state tax lien that's against David and Sarah. So David was also married to Sarah, and so they have an old tax lien out there that needs to get paid off. Tax liens are not typically something that's really necessarily easy for us to get to, because they don't want to talk to a third party. We're considered a third party. So often in this case, for instance, David is going to have to let his person that's been assigned to his case, because everybody gets a notice. Once a state tax lien goes out, they get a notice that Mary Sue is your contact for your case. So he would have to get with Mary Sue and have her say, yes, that's fine. You could give this information to Kaufeld, or just go ahead and say, send this payoff information to Kaufeld. Here's their information. So I just point that out because sometimes those are not super easy to get because they don't like to talk to us. Then they're also on item 12. This is just talking about there's homes association on this property, and we're requiring that we get the information from the homes association. So we need a invoice. A lot of these homes associations are now having a management company handle that, which is good and bad. Bad in the respect that they're not super quick, but good in the fact that we can at least get a hold of them. Sometimes when we deal with homes associations that have individual homeowners as treasurers, they go on vacation or they resign and nobody's been reassigned. It's just, sometimes that makes it a little bit more challenging. So in those scenarios, sometimes we do have to get the sellers involved. We had a homes association probably a year ago that they did not respond to us at all. And the seller literally, and they didn't respond to the seller either. So she had to go and knock on their door to discover that that treasurer no longer is the treasurer. But he was able to give her at least the information of who to go to now. So those are the types of things that sometimes we do have to get the sellers involved. If it's a management company, usually we can get those. Again, not quickly, but we can get them. Mechanics liens. Okay, a mechanics lien is when someone has done work, they've had material delivered, they have been on the property for any purpose. They can file a mechanics lien if they feel that they have done any kind of justifiable payment back to them. We don't have a ton of mechanics liens. Most people pay what they need to pay. it's typically handled, but once in a while we'll see those pop up. If there's a mechanics lien filed, it's just like any other payoff. We got to get the payoff statement in from Joe Foundation, and we, pay that off through closing. So,
Anything that's common on like small, new construction or anything like small builders or anything like that?
we don't, again, we don't see them a ton, even on small builders, because those builders realize they need to use those entities again for the next property. It is in Missouri a requirement that a notice of intended sale is filed at least 45 days prior to closing. If that is not done, we're required to do a mechanics lien search. Mechanics lien search is done by an independent third party. They contact the builder. The builder has to give them all of their vendors that they've used, proof of payments, all of that. And then that mechanics lien inspector then contacts these vendors to make sure that indeed that they have been paid. Then we get a report back, and we basically then can use that to avoid the 45-day notice with the state, but also to be able to be in the position to insure the buyer, so that that foundation guy, that concrete guy, that whatever, can't come back after and say, hey, you owe me for this, because now you're the owner to it.
I did the notice of intended sale on the property there. What happens with that? What do you do with that notice of intended sale?
The notice of intended sale is filed with the county, so that anyone is on alert to the fact that that is coming up to closing, and that if you want to, Mr. Contractor, file a mechanics lien, you have until X date to file. It's mailed back to the builder or the investor, and then they're supposed to post it on the property.
Okay.
Now, with that being said, any mechanics lien filed, typically that contractor has found that through just pulling it up online. Now, but the way the Missouri law reads is that it should be posted. I will tell you, a lot of builders and investors don't like to do that, because when it's posted, to see that from the street, it looks like a foreclosure. It looks just like a foreclosure notice, unless you come up upon it and read it, but nobody wants that posted on their door type of thing. But the way their law reads, it's supposed to be posted. In that situation, we still have to pay it. Then on the backside of that, then they would have to sue that contractor and pursue it, getting reimbursed on it in that scenario. Yeah.
But if the guy that did the work doesn't do anything in that window, then they can't come back on that and on the backside.
Right. That's the beauty of that's the beauty of the notice of intended sale.
Okay.
Disadvantage is that you got to wait. If somebody forgets to do it, you got to wait 45 days to close, or have that mechanics lien report done. The mechanics lien report, to file a notice of intended sale, it's $30, $35. But to do a mechanics lien report, it's $250, $350. So, and a lot of paperwork, some time, etc. Although it's quicker than 45 days. He gets those done usually, as long as everyone is cooperating, he can usually get those done within a week. So, mhm.
Someone that did work and it was done so poorly that they actually had to come back in and redo the work to actually correct the issue.
Yeah, and we do hear that. I mean, not necessarily that, but whenever someone is in a dispute, of course, it's a he said, she said situation. I don't get involved in what's right or wrong.
Yeah, I
But
that way I just kind of have an idea of like when I actually, if I do get a contract up installed.
when was the work done? How long ago?
So the work was actually done, supposedly finished almost a year and a half, almost 2 years.
Okay, so when was I probably should rephrase this. When was the last time that entity had any materials or stepped on the property?
The last time that vendor was on the property was probably bare minimum 8 to 12 months ago, because it was before I took the listing.
And have they filed a mechanics lien? Okay, so
He's not
the statute to that is 6 months. So,
months.
so someone has 6 months to file mechanics lien. Sometimes the contractors get around that, or vendors get around that by coming and delivering something, or coming and doing a little something on the property.
Yeah, no, he hasn't.
So that's why, yeah. So,
I changed and everything,
mhm,
and like, he doesn't even have a lockbox on this property.
yeah.
Super box it.
Yeah, you have 6 months from the last time that I'm just gonna say step foot on the property, because anybody can do anything on and say, oh, I did work. I planted this flower, I did work.
I just want to make sure
But-
that like he was that end of it because of how things have gone with this guy, and
Yeah,
I don't
Or-
think I don't think he's smart enough to figure out how to file those pieces of paperwork anyway.
yeah,
Knowing this,
Yeah.
knowing the contractor.
yeah. Well, to get too involved in just that one particular scenario, and I'm gonna say overall, we're gonna say that as long as he hasn't had anything delivered to the property or been on the property, he has 6 months from that point to file a mechanics lien. So as long as he doesn't have something delivered there, then, or on the property, then you should be fine.
Okay.
So, because you have to have 6 months for that. Okay? Yep.
Say, somebody say a young guy bought a house, he lived there, did everything himself,
Mhm.
redid the entire house, he doesn't have to file the notice, correct? Is it only just contractors? Say he spent $150,000 of his own money, did all the work himself, no
Mhm.
contractors.
Mhm.
Does he still need to file a notice?
Or does that require if they pull the permit?
The permit I'll answer that one first because it's the easiest. Permit makes no difference. To answer your question, technically, the way the law reads, yes, he's supposed to have that. Because remember, that's if any materials or anything are also delivered. Now, have people done it that way? I'm sure and then we don't know about it. People do improvements to their houses all the time. And they don't file, notice of intended sales.
And that's only for big stuff, right? If we change the colors, change the paint, things like that, we don't really do those, right? Unless we were having somebody come in and paint for us. But if I just
The
paint-
way it reads, if you have anything with the intention of like an investor situation. So if I'm going in and I'm painting my house, I went to Lowe's, bought the paint, brought it home, painted the house myself, which would never happen. But if I did, then no, that doesn't file under mechanics lien. I have no intention of flipping the property. That was not my intent when I painted.
Sell it, make it nice, then you.
Typically you're still okay. The big thing is that they're trying to give the way the state wants that is so that it gives anyone that has done work or had something delivered to the property the opportunity to know that they need to go out and file a mechanics lien if they have not been paid. That's really what what it's for. It's kind of spiraled a little bit, but nevertheless, that's kind of what it's for. Most of the time, if somebody's owner occupying their property, they're doing it, like you said, just to spruce it up so that they can get it sold at the best value. Typically, that's not an issue. Now, when they start getting into like having people deliver stuff and having work done, then that's where the gray area really gets into. Technically, the way it reads is you're supposed to. Do people? Probably not. But if we know about it, if it's disclosed to us, then it has to be. So, let's see here. And then item 14 is David and Leanna, who currently own the property, there's a pending divorce. So they're getting ready to divorce. That one we don't have to do anything about unless unless that divorce gets finalized. So between contract and closing, if it still stays pending, if it doesn't finalize, there's nothing that we need to do about it. Now, the proceeds, that's usually where my next question is asked, is payable to David and Leanna together. Now, we can, because we're on notice that there's a pending divorce, we can split those proceeds as long as they agree upon it. So we don't care how the split is done, 50-50, 60-40, flat 5,000 to one, the rest goes to the other. We don't care. As long as they're in agreement to that, we can split those because we know that there's the pending divorce coming up. Stepping back, one big thing that we have to keep in mind is that if it's titled, the owner to the property is a trust, the proceeds has to be payable to the trust. The trustee cannot assign proceeds to someone else. They cannot have the trust or the proceeds to them individually because they're the trustee. It has to be payable to the trust. So if you see that you have a seller that is a trust, or you discover, because a lot of people have no idea their property is in a trust until the title commitment comes out. And then all of a sudden you're trying to say, okay, is my seller the right seller? And you're like, holy moly, it's in a trust. We're going to need a trust certificate. But that is the point in which you want to tell your seller, hey, if you don't already have an account that's payable to the trust, you need to open an account payable to the trust. Because the bank, it's not something that the bank can instantaneously do like they do for individual people. It's an entity. They have to do what we're going to have to start doing with kind of a FinCEN thing. They have to be responsible to the government to determine that this entity is allowed to get funds.
Which I ran into mine.
Oh, yes, we talked about this.
My seller had to open a bank account in the name of a trust in order to get that proceeds. It couldn't go into her bank account. That's new for me.
Yeah, yeah.
So they did that. But
yeah.
I'll be mindful of that next time because most people, I don't know that most people have a bank account for their trust.
I think they're supposed to. I think when you get it.
Yeah. It is, but the trust attorneys often leave that to you to do. They say, here's your responsibility, go open up an account.
Banks, get the account. That's I just am messaging mine right now.
Yeah,
Yeah.
but if you also, I'm going to go back to that too because I want to point on that. But if you have a seller that says, oh yeah, I think my account's payable to the trust, don't think, check, call the bank, because they'll have time between the time you find out on the title commitment and closing to confirm that. Because I just literally had one that thought their account was in the trust, and it was not. It was payable on death to the trust, but it wasn't entitled to the trust. So those are kind of the differences to that. And then also, if you don't have a seller that has an account that's payable to the trust and they don't want to mess with it between now and closing, then we can cut them a check, again, payable to the trust, and they can take that check and their trust agreement to the bank and do it all in one foul swoop. So that's also an option too. Sometimes people are just like, this is too much for me right now. So, but they have to be aware that, you know, they get a check, their bank might put a hold on it for a while. So, then the next section kind of talks about taxes to see if they're paid current. If not, that also becomes something that we have to handle through closing. Right now, taxes are coming out for 2025 in most counties, or in some of the counties, they'll all be out here pretty soon. So we'll have to pay those at closing because they become a priority lien. So what questions can I answer on this? Yes, sir.
Happens if the liens out. Sales prices.
The seller owes to close. So the seller has to bring funds in to be able to close. It happens. On my side, it just can't close. So what happens beyond that, it's left up to the individual person. Either they don't sell now and they continue to live in the property and they pay their debts down, whatever. But the bottom line, or you do a contract negotiation at that point, depending on how much it is, you know. But we do have scenarios with sellers owe to close. I mean, it's not often, but it does happen. So it's not really, I don't want to say odd, but it does come up. It probably comes up once every other month. So they're paying to get out of the situation. And a lot of times it's not a ton of money, and often they know about it. Even if they don't tell you about it, they know. It depends. I mean, mhm. Mhm. Yeah. Yeah. So, I mean, sometimes you get to those where you have to renegotiate a little bit on the contract. Your buyer may or may not want to do that. You know, it's just kind of, you know, kind of left up to that. Let's see here. I'm going to take a look at some notes that I have. We talked about vesting, how important that is for you guys to look at once you get those title commitments in. It's really important that you don't just put those title commitments in your, I'm going to use your dot loop, thank you, or whatever it is that you submit to admin command, thank you, without looking at it. You know, don't just check it off your box. Oh, I got that in, here it is. Because those are the ones that people are like, I had no idea there was a judgment, you know, and so just kind of be aware.
Some
Mar-
of that shows up in the MLS, because that's how I found out that mine had like, what, $5,000 or something that they owed on a second because of some issue. But it was right there at the bottom on MLS.
Oh,
Before I even got the, from you guys.
oh, okay.
Because I came in and asked. What
Interesting. Yeah. Yeah. I didn't know that happened. But then again, I don't see that side of it
Right.
either. So, the closing statements, I know that that's not what this class is about, but when you get your closing statements in, we always send those out for you guys to review. If you have not seen one from us, at least by the day before closing, contact us. Either we just missed getting it sent to you, or B, we're still outstanding something. And that's the reason why. Scheduling sellers, keep in mind, get those scheduled ahead of time. Don't wait until the day of closing to schedule your sellers, because if time-wise, it just doesn't end up working out to get your seller in early, because they have moving trucks, which almost always happens. Moving trucks are arriving at 7 a.m. and they cannot leave. And then we'll be there at noon. The moving truck didn't get done. We'll be there at 1. The moving truck didn't get done. And then all of a sudden, it gets too late in the day to get recorded and dispersed. They need that money to just take that moving truck to the new house they're getting ready to buy. So get them scheduled ahead of time. So it can be day 2 whatever. We can even schedule a seller in a week ahead of time and then have them e-sign the closing statement. At least they get their notarized documents done. And sometimes that's a great breather for your seller, because they can get in, they can get that done the week ahead or 3 or 4 days ahead, whatever. And that's taken off of their plate. That's not something they have to worry about appointment wise anymore. So that's always something great to offer them. We have to have contracts in to be able to post earnest money. Earnest money, as you know, is on a very short time frame from the time the contract's written until we get it, especially if it's on a Friday evening and we're not back in until Monday or maybe Tuesday if it's a holiday. We get earnest money in and sometimes we don't have the contract. We can't legally, we can't post or take in earnest money unless we have a contract. Now, we have as normal practice went ahead and accepted that. We just can't put it on deposit until we have the contract. So go ahead and send us the contract. Even if you don't have anything else done, just go ahead and send us the contract in. That way we have the contract. When that money comes in, we can get it posted so that everybody's within their right time frame. You don't have to do an amendment, anything like that. We talked about making sure the seller is who is the seller in title. Let's see here. We talked about payoff authorizations. Those are the big things that kind of hold us up from being able to order payoffs. Lenders seem to be taking more and more time to get us the payoffs in. Often we could get them in 24, 48 hours. Now we're seeing some that are stretching those out 5 to 8 days. So it's important for us to get those payoff authorizations in so that we can get those payoffs ordered. The wire fraud form, that's another thing that's recently came up. I told Tim I wasn't going to talk about this, but here we are, that we need those in regardless if your buyer wants to pay for that and pay their funds to close in a wire, or if they're going to pay that in a cashier's check, we have to have that wire fraud form in. Once in a while, we'll get people saying, hey, I'm not going to do a wire. I don't need to sign that form. We need that in regardless because things can change and we have to have that. So, anything over 100K, we have to get verified. Excuse me. Because of cashier's checks fraud. So we have to now, anything under 100 or over 100,000, we actually have to call the bank while the client is still here. Most that we have had so far have been very easy to verify. Many moons ago, I used to work for CapFed, and one of the things I did was verify cashier's checks. And it's a very simple process. So when we get an entity that's hassling us, I'm always like, are you serious? The whole purpose of a cashier's check is they've taken money from the client's account, transferred it into, and we're just going to use Community America because we talked about them earlier. They literally take the money from the client's account, they put it in Community America's own account, and then they draw the cashier's check off of that. That's how everyone, Community America, the buyer, myself, everyone knows those are good funds because they've already taken that money. Nothing that the buyer can do to get that back because now it's owned by Community America. So in theory, then it should be very easy to go ahead and verify a cashier's check. Yes, cashier's check number such and such. It was drawn on whatever location, signed by such and such. Here's the amount. All should be good. US Bank, not so easy. They're the ones that have been the hardest so far. I have no idea. They want to verify that the funds that they got into their account really did come from their buyer's account. And my thought behind it is, had I not called you to verify it, that check would have gone through fine, dandy, no problem. So I don't know. And we actually had on one US bank, they just flat out refused to approve it.
They must have had something in the past where obviously they're doing that now because it bit them in the past somehow, some way.
Yeah,
But-
it could be, but I can't figure out what it is.
And the only one.
Yeah. Yeah, I'm not sure. We ended up getting that guy, ended up calling, fortunately, he was a large volume client. He was able to call his personal banker at US Bank, who contacted whoever he contacted. And then we were able to call back. They were expecting our call. That person approved our thing. But that ended up being 30 minutes. Like literally, the client is sitting in the closing room for 30 extra minutes for no reason. Reason, but it should have been easier, you know. But that's the cashier's check thing. Yeah. 100,000. Yep. Let's see here. The only other thing is that when we send an email out, do try to take a look at that. I know everybody's busy. I'm not saying drop everything that you're doing and look at it, but do get to it at some point, because usually we're asking a question or we're needing something or whatever the case may be. We're trying to get you information, something like that. So just keep in mind if we're sending something, we probably need something. So anything else that you guys can think of?
For people like doing title searches and that stuff, how do you do that outside of a title?
You just go onto the county site and you just start searching. First of all, the property, typically that would be your first step, and then start searching people's names. It can be done. Obviously you have no insurance on it, you know. We once in a while will have people come in and say, typically between family members, saying, hey, I want to do a deed from mom and dad to daughter and son-in-law, and can you guys do that for us? No, we cannot do that. We can only do a deed if we're providing title insurance. We can't just do a generic deed. When FinCEN comes, we absolutely cannot do anything other than what is contractually stated. But we weren't able to really, in our area, we weren't able to do that anyway because of title insurance purposes. But we always advise everybody that although mom and dad seem to know that their house is free and clear and that they don't have anything against them, I can't tell you how many times people come back in and say, oh my gosh, I bought this property from my mom and dad 5 years ago, and now I'm trying to sell it. And then there's this lien against the property from my mom and dad. They didn't pay taxes one year or something. So, you know, something came up and now all of a sudden that there's this judgment. Mhm.
Say like they have like a $3,000 mechanics lien or something.
Mhm.
And then the guy goes out and pays that contractor the $3,000.
Mhm.
Does that lien come off, or do they have to file something?
They have to file a release of it. Or a satisfaction. Yeah.
Okay, so I'm sure that probably has come up, like, hey, we paid those contractors,
Mhm.
but there's still a lien on the property.
Mhm.
How do we go about that? Just have to get the proof of receipt or have the contractor sign off, or?
Site contractor's going to have to sign off. The receipt's not going to do us any good. A lot of people want to show a canceled check. They want to show a canceled check for homeowners association fees. They want to show a cancellation check for things like that. A canceled check, excuse me. But we have to have an actual satisfaction sign so that we can file it with the county that releases that lien. Along that same lines, once in a while, you'll have especially lines of credit. So a HELOC line of credit, somebody will have paid off and told them to close the line of credit. That it's true, they did that. It's a zero balance. But what they didn't say is that they wanted the lien released. They wanted it closed, but that doesn't necessarily mean it gets released. It just means they can no longer draw upon it, but it's still there. Now, you would think logically the bank then would say, okay, well, you want it closed, so do you want us to release it? But that doesn't always happen. So in those scenarios, so that we can get closed, we will request a zero, what's called a zero balance payoff from that line of credit. And then at that point, then we put them on notice that that needs to be released of lien. So,
Concrete work, had a lien against it, and I paid him. So then do I take them a piece of paper and say, and where do I get that piece of paper? And then do they have to do anything, or do I just get that piece of paper back and give it to you, or what's that process?
we can prepare that satisfaction for you.
I'm just
If
thinking
we're,
it's
if we're
not-
involved in the transaction, if we're involved in the transaction, then we can prepare that
Okay.
satisfaction for you. That has to be notarized and it
Okay.
has to be recorded. We can record it. We can also notarize it, obviously, if they come in our,
And sign it,
yeah.
okay.
Can't anybody just go file a mechanics lien?
pretty much. Pretty much. I mean, once in a while, you'll hear people, and of course, we're getting the one side to it, you know, the seller side to it, saying, I didn't even have them do the work, you know, therefore implying a bogus mechanics lien. There's nothing we can do about it. That would be something they'd have to hire an attorney for and get, and get that released. Yeah, yeah. I mean, when you go down to the county, you can really file anything with anybody about anything. I mean, the county's responsibility is not to verify that that is a valid document, valid lien. We have a good county in Cass County, and they sometimes will be able to kind of glance over a document and say, this is supposed to have a legal description on it, or this not quite right. But that's not their job. Their job is really just to record it. It's out there in the world, and then, you know, then whatever happens beyond that happens. Mm-hmm.
Say a death happens, they don't have a trust, and it goes in, kids kind of inherit the property, but it's never stated anywhere. How does that, I guess, probate?
Yep. Because we often hear people say that they've inherited the property. That's not, even if there's a will out there, often that's the big thing. Well, in their will, it shows that me and my two brothers get the property. That will, what's good about the will is that they can submit that will to the probate attorney. And then that'll be submitted to the court basically as evidence of this is what we're going to say parents, intended to have happen with the property. Now, that doesn't mean the judge has to do it that way, but you'll probably see 95% of the time that's what it's going to happen. But it still has to go through probate. What's the best thing to happen is to have a beneficiary's deed filed. The beneficiary's deed is what they call a silent deed. It must be recorded prior to a person's death. Once in a while, those are recorded after someone dies. That does not make them a valid deed. It has to be filed prior to someone's death. And then that silent deed then slides into place only when the current owners are deceased. No. In fact, the beneficiary deed doesn't help, because the trust in itself sets out what happens when the settlers / trustees die. Then the successors trustees slide into place. And then if there's what happens if one of them or two or whatever, what happens next, it's all set out in the trust on what happens. Mm-hmm. Correct. Yeah. One of the reasons, and the other reason is just the fact that the individual people don't own the property. They confuse themselves as being settlers and trustees as owners. That's not the case. Now, they direct what the trust does, but the trust is the owner of the property. Just like ABC LLC, or same scenario. It's an entity.
And Sam, Big Sam, are you guys doing, preliminary title searches?
We can do, I mean, we could do preliminary title searches now, but we are not going to do them on every property. That would just be impossible for us to do. Fencing really, keep in mind, fencing is only kicks into play when you have a cash buyer that's an entity. That's the only time it's going to kick in. Cash buyer that's an entity, LLC, trust, corporation, partnership. That's the only time. So if you have a cash individual buyer, husband and wife, single person, whatever, doesn't apply to fencing.
Well, just, you said a while ago, unless you're contractually obligated to do so,
Mm-hmm.
preliminary search are not contractually obligated to check the property.
Mm-hmm. Yeah, true.
So, I don't know if it would come back on, why did you leave it on work on?
Yeah, no, it doesn't, because keep in mind a preliminary is only done on the seller side. So at that point, we would actually be able to say, okay, well, we did the work, even though we didn't do the in transaction, we did the work only to find out ownership, current ownership to that. Otherwise, we don't do preliminary title commitments for a buyer side because that's a contract. So, yeah. Anything else?
Well, this is very good information, and thank you.
You're welcome.
Especially for someone like me, that's like, I get those emails and I look at them, I'm like, okay, I think that's.
And
I'm
it's
gonna go with that.
It's kind of nice. Our examiners, when they do the title commitments, they will bold the stuff on B2 or B1, excuse me, that needed to be taken a look at.
Yeah.
Now, they're not required to, so don't count on that as being, so if you see a B1 that has nothing bolded,
Yeah.
still look at it. Or look at the whole thing. But they're really good about bolding here, look at this, type of thing. So yeah, for sure. And it's also helpful when you look at those and you discover, just as Tony was pointing out, that if you don't have, if it has to go to probate or those types of things, it can be done or viewed early on for those requirements. Yeah. Because so often you'll run into people that'll be like, oh yeah, we inherited the property. They don't tell you they inherited the property, but after the fact and questioned, well, who is mom and dad showing on here as title?
Right.
And they're like, oh yeah, we inherited the property. It's in the will. We get that. No. If it worked that easily, yeah. And when people do have wills, I mean, wills are not to be just, disregarded. It does help the probate process for sure, to get it through. Yeah. Mm-hmm. But the sooner that gets, goes through probate or at least gets started, because those have to be, posted and that type of thing. So that's the purpose of probate, is so that they can put it out there to the world. This estate is getting ready to settle. So, or we're working on it at least. So if you have a claim, now's the time, you got to step up. So. Yeah.
Thank you, Lisa.
You're welcome. You are so welcome.
More class, all that knowledge up there.
I know when I watch her closing, I'm like, "Good Lord, I'm so glad she knows what this is."
She's reading it all upside down.
Darren tells you you're supposed to be able to read the contract upside.
That's what he said. I can read the key pieces, but not. I was a keeper, so I did that back in the day. How much that?
Thanks again, Lisa.
Welcome.